part of the conversation.
Or I could just...
Let me introduce to you the moderator for this. This is one of my esteemed colleagues, a law professor at Case Western Reserve. He's the director of our Institute for Global Security Law and Policy, which was originally started by Amos Giora. Amos, are you still in the audience here? Well, it's a shout out to you. You'll see him later. But it's one of the organizations that has done some really outstanding stuff here, and we're really glad to have Bob moderate this. This is a different kind of format than you see at most conferences. There's a lot more people up here, and they're not talking heads. They're not going to be reading speeches. But let me just say to the panelists, for this to work, you guys really have to keep your answers short and punchy. So about 2 minutes max for any given question, and that way we can cover a whole lot of questions. I now turn it over to Bob Strassfeld.
Thank you, Michael, and welcome. And I don't have to introduce myself now, so instead, let me introduce the topic of the panel and the panelists themselves, and I'll try to do that quickly to leave lots of time for their conversation and then some time at the end for questions from the audience. This panel is going to focus retrospectively on the military commissions. Shortly after 9/11, by executive order, the Bush administration outlined the basic plan for military commissions to deal with people captured in the global war on terror. And that outline, which was later flesh was added to, quickly drew criticism from any number of people within the human rights community, critics of the administration, civil libertarians. It has undergone change. Congress, both due to litigation and congressional legislation, and is now again being revamped. Almost 8 years after the executive order, the track record of the military commissions is that there has been one guilty plea entered and 2 guilty verdicts. 3 trials, a little bit less than 8 years. We'll talk about that. This panel is an extraordinary collection of people who are capable of addressing questions relating to the military commissions, almost sitting in alphabetical order, but I'll introduce them in alphabetical order and tell you who's who. So sitting at the far end, furthest away from me, is Colonel Morris Davis. Colonel Davis was, you have fuller biographies. I will try to make these reasonably quick. He was a judge advocate in the U.S. Air Force from 1983 to 2008, and most notably was chief prosecutor for the military commissions at Guantanamo from September 2005 to October 2007, when he offered his resignation for reasons that he will undoubtedly have an opportunity to explain in the course of our conversation. He is currently the director of, the assistant director of the Congressional Research Service. He is also a graduate of Appalachian State, where he earned his BA. He earned his JD at North Carolina Central, a law school that our law school has a very special relationship with, and we'll talk about that later. Not all of us, but Colonel Davis and I. And an LLM from GW. He is a government employee, and he and Captain Petty wanted me to point out that they are speaking on their own behalf and not on behalf of the United States government or anybody for whom they work. To my immediate right is Lawrence May. He is the W. Alton Jones Professor of Philosophy and Professor of Law at Vanderbilt University. a graduate of Georgetown University School of Foreign Service, and the New School for Social Research. And actually, I want to talk with you about Hannah Arendt later, but we'll leave that for later as well. With a JD from Washington University. He has published extensively, including 3 books on questions of international criminal law, war crimes, and human rights. To his immediate right is Gregory McNeal. Gregory is a graduate of this law school. He was an important part of the Institute for Global Security Law and Policy, for which I thank you on behalf of the Institute. And he is currently a visiting assistant professor at Pennsylvania State University Dickinson School of Law. And he has published extensively in this area in a short period of time. I'm skipping Keith because he's alphabetically last, and to his right, I've suffered with that all my life, Keith. And to his right is Mike Newton, who has contributed enormously to the intellectual life of this law school. He has been here on several occasions to speak at gatherings like this. He is a graduate of West Point, former JAG officer, taught at the military academy before his current position as professor of the practice of law at Vanderbilt University Law School. He is numerous articles goes without saying, and he is also the co-author with my colleague Michael Scharf of The Enemy of the State, the Trial and Execution of Saddam Hussein. Keith Petty, who is in the middle, is a graduate of our law school. He is a prosecutor in the Office of Military Commissions, has been involved in the Cotter case, and I think we better start talking about military commissions in Guantanamo. But there are fuller biographies, and they're all very impressive. So let me start by asking, in effect, what was the Bush administration thinking? Why did they decide to go the route they did in adopting in using military commissions and in designing them the way that they did? And let me throw that one to Mike Newton first, who is scribbling.
Well, I just wanted to make sure you asked 2 parts of the same question in using and designing, and to me those are very different questions. I think for the last 8 years, many of us have been saying, what were they thinking? I mean, that's not a new question. My perspective on answering this question is the fact that on September the 12th, the morning of the September 12th, we walked into the Deputy Secretary of State's office and we said, what are you going to do with the ones you capture alive? And we sort of got, don't worry about it. And then we got called back that afternoon and said, start thinking about it, which led to the publicly reported, there was an interagency task force that began to think about those questions seriously, carefully, with good interagency coordination. The government is fed by interagency dissent, and which we had lots of. We had uniformed lawyers. We had all the right people asking all the right questions, which was all short-circuited almost overnight by the November executive order. And so to this day, and there's many more stories behind that, nobody has ever offered a full and clear explanation of exactly what they were thinking, why they short-circuited that careful process. And I really, truly believe today that many of the problems and many of the legal difficulties, had they been handled properly in the fall of 2001, we wouldn't be sitting here today and asking many of the same questions. And having been in the room, it's not just Monday morning quarterbacking. I was in the huddle, and I can tell you that what were they thinking? There was careful thinking going on that was short-circuited.
Well, there was careful thinking by the interagency task force, but there was obviously also thinking going on in other parts of the government. And I guess I'm asking to speculate, or perhaps after the fact it becomes clearer, why the shape and form that they took. And I'll let you respond if you want, or I'll turn to someone else.
Well, in the early form, you mean in the early, very early
Yes.
period. I think it was a product. The word arrogance was used this morning. I would subscribe to that for particular people at particular points. The other word that I would add is a very insular approach. We don't need to talk to people. Well, we don't need to have broad consensus. We don't need to solve, and as the Obama administration is finding out today, some very complex, nuanced legal issues. Let's simply pronounce what we believe to be the right answer. People will accept, and therefore we'll move ahead. And the overriding interest, I believe, was both the unitary view of the executive, but also expediency. It was fast. It was easy. There's almost an artificial sense of urgency. And therefore, we just don't have time. Don't you know we're fighting a war? Well, yes, we read the papers about that. But in fact, there were complex, nuanced legal issues that had to be worked carefully. And that fundamental mistake, then, the follow-on question is, why did they take the form that they did? That mistake is then compounded over and over and over again about an insulated, secularized approach that doesn't ask the hard questions and doesn't carefully work through them on an interagency basis. And that mistake then propagates itself to explain many of the early problems, which were then corrected over time. There wasn't, in many cases, questions that weren't recognizable. They simply were short-circuited and bypassed.
No.
Yeah, just to add, I'm not quite as charitable as General Altenberg is. I would say it's arrogance and ignorance that led to where we are today. And I think, as he accurately described, I think the Kieran case, to the administration was the model. In the Kieran case, it was 49 days from capture to execution with a Supreme Court decision thrown in the middle. And I know how many times I heard as chief prosecutor from Jim Haynes and others, my God, in Kieran in 49 days, they were dead. What's taking so long? But I think, I never correct General Altenberg because it never fares well when I try. But there was another military commission. After the Kieran, Kieran is the famous 8 saboteurs that everybody knows about. In November of 1944, there were 2 more Nazi saboteurs, almost the same scenario. Submarine dropped them off. Within a few days, they were captured. And when the president had a chance to do it again, he didn't follow the Kieran model. The model that we used for the military commissions in 2001, when Roosevelt had a chance to do it again in 1944, he rejected that model. And he appointed a military convening authority. The case went through the normal military court-martial post-trial review process. So I think the reliance on Kieran and the ignorance of the later military commission obscured the vision of a lot of people and led us to where we are today.
I'm going to hand the mic to Larry.
I just wanted to add one quick thing to this, and that is that I think what led to where we are now is that the Bush administration had contempt for international law from the beginning of the beginning of the administration. I mean, when people asked about the Geneva Conventions, you might remember folks saying, well, they're quaint, they're old-fashioned, we don't have to regard them. I think that had an awful lot to do with where things went. It would have been easy. We have, 1,000 years worth of theorizing about these kinds of things. And just because there's war doesn't mean that anything goes. And the Geneva Conventions were sort of product of that 1,000-year history, and it was just utterly disregarded in ways that should not have happened.
I think to take a look at it another way, there is no doubt that there was disregard. The comments like they were quaint is problematic for those of us who studied the laws of armed conflict. That being said, General Altenberg alluded to the analysis that when you do apply the Third Geneva Convention, some would say that there is no doubt that al-Qaeda detainees do not qualify for the protections of Geneva III as prisoners of war. They don't meet the requirements of Article 4 of Geneva III. So if there was a legal analysis done, perhaps that was what they had considered.
Just to
add briefly to that. I mean, of course, the question is whether there are gaps in Geneva, right? So that folks actually fall through. And as you may know, there's quite a bit of debate in international law about this, but sort of definitive texts on this, the sort of commentaries on the Geneva Convention say quite explicitly there are no gaps. If you fall out of one category, you're clearly in another category. The Geneva Conventions always apply, is the way in which the standard interpretation is given.
But I would disagree. Even Pictet in the commentaries to Geneva 4 says that those who are fighting unlawfully, to paraphrase, know they're taking a risk. And that risk is that they will not fall under the protections of either Geneva 4 and, by analogy, Geneva 3 if they don't qualify for the Article 4.
So, wait, so can I ask
let's for the sake of our non-lawyer audience, let's put this in context, right? So you've got a set of binding international treaties that apply to armed conflicts between nation states, and then there are, in that sense, they are quaint, right? Those aren't the kind of wars we generally fight these days. We fight non-internal armed conflicts in the Congo and in Central African Republic and in Uganda, where Michael and I have done a lot of work. And of course, now you have a non-state actor with a transnational reach and a lethality beyond any lethality that anybody would have imagined on a sustained basis. So then that raises a very complex set of questions, which in fact there's lots of debate among the scholars. And I go back to what General Altenberg said, which I fundamentally believe as a uniformed lawyer. Remember, it was the uniformed lawyers who said, yes, we can make the legal debates. Our job is to be in the field to give operators fundamental, clear guidance that complies with the law. And this is actually an important illustration of what Larry generally referred to. U.S. Armed Forces policy, this Joint Chiefs of Staff Directive, says we'll apply the law of armed conflict in all times, in all circumstances, no matter how the conflict is characterized, to the greatest extent possible. And in situations like this, where it doesn't fit precisely, which is clear, we will apply the principles and spirit of the law. So to me, on September the 19th, 2001, in the interagency group, the answer that General Altenberg and so many others have asked later is, do we need to do, don't call them Article 5 tribunals, because that's a creature of the Geneva Conventions. Do we need to do something like the Article 5 tribunals? To me, that's an easy answer. It's a 3x5 card answer. Of course you do. Why? It's the law. It's our policy. It's common Article 3. There's a long list of reasons why. And so, be very clear about this. It took affirmative interference from the administration and from particularly appointed political officials to stop the normal functioning. The normal status quo default rule would have been to do those kind of preliminary hearings and to apply the principles and spirit of the law of war. So there were difficulties encountered that were in fact short-circuited over time.
I want to turn to another question and to look specifically at the two trials that we do have a record for, and ask, to what extent would those trials have been different had they been either before a court-martial or in an Article 3 court? Would the outcomes have been different? Would there have been significant procedural differences that might have mattered? Or could they have been tried in court-martial or an Article 3 court? Greg, I'll start with you.
So I think so let's take Hamdan as the first example. Hamdan, you all might recall, is oftentimes referred to as Osama bin Laden's bodyguard, or the one that bothers me is Osama bin Laden's chauffeur, as if sort of he's driving around in a Bentley in Kabul. I mean, Hamdan was picked up heading towards the fight when everyone else was headed away from the fight. And the evidence we had against him was that he was in a truck filled with surface-to-air missiles, and the only people flying over Afghanistan at that point in time were coalition forces. So we can call him, Hamdan's bodyguard and just one of these people who's just wrongfully swept up, or just a low-level player. But you don't get to hold an AK-47 next to Osama bin Laden unless you're someone who's pretty trusted within the al-Qaeda network. And his sentence was, I think some people looked at it and said, look how fair this sentence was to him, and I think that he probably would have been sentenced more harshly had he been tried in an Article III court. I'll defer to Colonel Davis on how usable some of the evidence would have been in an Article III court, but I think we had photos of the truck and the surface-to-air missiles, and so as long as you could authenticate that, you probably could have admitted that. When you get into the testimonial evidence, that's the sort of issues that we have a problem with in an Article III court. But he's sort of the easy case. The harder cases are the ones where we're relying solely on intelligence information that would really complicate issues in Article III courts.
Yeah, I think, with the three cases that are done, I don't think have been a good test of the system. So I don't know that you can draw a lot of conclusions from what has happened. The three cases have been done in 8 years. Hicks was a case that I inherited when I became the chief prosecutor. And one of the things in meeting with the transition team for the new...
You should explain that Hicks is...
Oh, I'm sorry. David Hicks was the Australian that signed up to be a part of the Taliban and Al-Qaeda and was captured in Afghanistan and wound up at Guantanamo Bay. And Hicks was a guilty plea. Al-Balul was sentenced to life. Al-Balul boycotted his trial and refused to participate, so that wasn't really a robust test of the system. Hamdan probably comes the closest to being kind of a test drive, but again, as you said, there were photographs and other physical evidence that doesn't exist in a lot of the other cases. So I don't know that you can draw a lot of conclusions. I think even though the rules don't measure up to Article III or UCMJ standards, my impression has been that the judges are applying a higher standard than the Military Commissions Act requires. I think the one good thing that's come out of this is, as General Altenberg alluded to, I think there's still a lot of confusion about military justice and military lawyers and that kind of thing, but I think there's been a lot more light shed on that over the last 7 or 8 years than before. I can tell you, even talking with members of Congress, I think there was a lot of ignorance about the UCMJ being some second-rate standard of justice, and that military lawyers, as General Altenberg said, were just going to come in and plead their clients guilty, and this was all going to be over and done in 49 days like Kieran. And I think it's been a shock to a lot of people that that's not the case. And I know some of the members of the civilian bar that I've talked to said that it was really eye-opening to them to see what a robust system that military law is. So I think the judges have applied the higher standard, higher than they were required to apply. So I don't know that the outcomes were remarkably different than they would have been in a court-martial. But that was by virtue of having good people in the process, not good rules for the process.
Right, and I think that's the point that Colonel Davis is bringing up is sort of an important one to highlight, that we started off with, as Mike Newton pointed out, an executive order that constituted these military commissions. And one of the points that the Supreme Court made in Hamdan in overruling those military commissions by executive order was that the structure mattered. It was, we trust that military officers will do the right thing, but trust alone isn't enough. Structural fairness is what we're looking for. And so that's not to impugn any individual players. That's just the nature of a fair trial, or at least in the Supreme Court's interpretation of that. And so some of this is path dependence that we're dealing with. Those initial early decisions led to that we tried to move forward in military commissions constituted by executive order from 2001 to 2006. It took 5 years to hit the reset button. It's kind of why we have only seen 3 trials up until this point.
And that raises the important timing question. Remember, the executive order comes out in November of 2001, and it is, as has been pointed out, roughly a cut and paste of the 1942 order. Sloppily done, lots of easy questions for informed, educated lawyers who say, well, why didn't you deal with this? Well, we should have dealt with this. There's all these gaps and questions, very poorly done, but hastily done, which was the executive's overriding objective. The immediate criticism, if you go back in time, the early criticism in the following days and weeks was, oh, but you haven't prescribed any structures. There's no, for example, clear standard articulated for finding guilt, for example. There's no clear standard for a whole range of things, which goes back to a point General Altenberg made. To do it right and to inform people appropriately it ought to have been done as a package. That would have required more time. It would have required interagency coordination. It would have required and the executive's response was pretty defensive on that. Said, well, of course we're going to have rules of procedure. Of course it'll be guilt beyond a reasonable doubt. But nothing documented said that at the time. And they fell back on that simple clause, full and fair trial. Of course, the executive order required full and fair proceedings. So we will then develop processes for that. But it had to have been done properly as a package, and it wasn't.
Can I add one more thing? You know, I think one of the fundamental problems was, you know, Guantanamo Bay was never, people weren't sent there to be prosecuted.
Yeah, that's right.
It was an intelligence operation. I mean, prosecution was a third or fourth order of magnitude on the scope. And that was one of the problems that I think a lot of folks, when they joined the prosecution team, you know, realized that you've got this box of evidence that's really intelligence. There were no rights advisements, generally, you know, no evidence tags, no chain of custody. It was intended to collect intelligence, not to prepare cases for prosecution. So it's years later when all of a sudden it's, you know, here, take this and prosecute this guy. And, you know, intelligence, you know, their objective is looking forward. They don't really care what you did in the past. What do you know about what's going to happen tomorrow? You know, on the prosecution side, you don't really care what the guy's thinking about tomorrow. You want to know what he did yesterday that he can be held accountable for. And those opposite perspectives just don't fit together neatly. And that's one of the conundrums, is trying to take intelligence and make criminal cases out of them.
Just to get back to your original point, Bob, I think the underlying question is, what was the quality of justice in the cases that we've seen? I think it's very telling, just days before the actual Hamdi trial, the defense filed their habeas petition in the D.C. District Court. In denying their appeal for an injunction of the pending trial, Judge Robertson said, you know, we are going to paraphrase, we're going to allow this commission to go forward. There are real judges in Guantanamo Bay applying real law. Article III judges do not have a monopoly on constitutional learning. Now, what followed was a case in the Hamdi trial where the government used no hearsay evidence, which is a big fear of what might come of the current military commissions. The only time the session was closed, so people are afraid of these secret closed hearings, was at the request of the defense. And when it comes to evidence that may be coerced or gained by untoward means, the judge suppressed evidence in the suppression hearing prior to the trial, not because Hamdi was the victim of any coercion himself, but because where he stayed in Bagram was, quote, an inherently coercive environment. So these are just examples of how the law was applied, how some of the worst case scenarios and worst fears of these military commission trials did not come true.
You know, one of the ironies of Guantanamo is the 3 cases that have been done, you know, 2 of the 3 are now free men today. They essentially got misdemeanor sentences for being, you know, as Donald Rumsfeld said, the worst of the worst. And they're free men. But, you know, there are more than 200 people that have never been charged and they're still being detained. So, you know, one of the running jokes is, to win at Guantanamo, you got to lose. You have to go to court and lose and be convicted to get your freedom, which is, you know, kind of a sad state of affairs for a system of justice.
But I think that if we look at just the result, then we miss a lot of the issues about due process that I think are highly significant. And that's the problem with the way things were handled, right? Is that while you might have had good people who were going beyond what they were required to do, we shouldn't have to rely on that as the problem, right? And so that's what due process does for us, is that it means that the bar is set higher and we don't have to rely on people being of goodwill in order for justice to be had. Well, I sit on this panel as both a philosopher and a defense lawyer, and I must say that I was appalled by what happened during those trials, but not by the result, and that's fair enough. But by what happened during is the problem, in that there were not clear-cut procedures that should have been, that protected the defendants in the cases in the way that I would have liked to have seen, and that I think both domestic U.S. law and international law would have required.
Yeah, I would just like to extend on that. What procedures? I mean, when the Manual for Military Commissions and the implementing rules fills 2 binders in my office, and lots of litigation and lots of pretrial motions, primarily by the defense. I know you're tired of responding to defense motions and litigating defense motions. So what in particular, and I think this is an important question as we go forward, and I know we'll have a whole panel later about the issues going forward, but are there particular procedural corrections that you really think need to be done, Larry? And if so, then we have the forum and the expertise to shape the right legal answers, and let's get them into the system.
Yeah, and I don't think that this is the right forum to debate these, but just to put a few on the table, were already mentioned. I mean, I think I was especially worried about hearsay and about the quality of testimony that would and did occur, and questions about to what extent it was coerced, to what extent there was a proper, I find, normatively proper challenge to the kind of evidence that was presented. So that's the kind of thing that I was thinking of, Michael. And you're right, though, of course. That's not to say that there weren't procedural safeguards in place. It's just a question of whether there were enough. And my point was only looking at just the result is not the end of the story. We need to look back and see whether we think the procedures were adequate.
Right.
On the assumption that down the road we may not have people of goodwill.
Right. Well, let me pick up on that, because, go ahead, I'm sorry.
We aren't relying just on people of goodwill. I mean, well, first of all, in every judicial system, you do have to rely on the integrity of the players, otherwise the system fails, even in the federal court system. But in addition to that, they have an extensive list of protections. I won't call it due process, because that would assume that they were entitled to some sort of constitutional due process, which we could debate for the rest of the day. But they had an extremely talented and deep bench for defense attorneys. They had two private attorneys, assumingly working pro bono from Perkins Coie. They had Charlie Swift, who had taken the case up to the Supreme Court previously with Neil Katyal, and they had a lieutenant commander in the Navy, also a case graduate. So he had so he had four attorneys sitting at his bench. They raised numerous legal motions prior to the trial, challenging the applicability of the Geneva Conventions, challenging the reliability of his statements that were given to law enforcement. So again, we come back to the question, perhaps this is for a later conversation, but what specific faults were there in his process? Again, hearsay wasn't used. Statements were suppressed not because they were coerced, but because he was in a, quote from the judge, coercive environment. I'm not sure, if we look just at examining the Hamdan trial, what was lacking on it?
Well, I think, I want to piggyback on Larry's point, I think, and sort of answer your question, Keith. I think that the problem is that it wasn't that either hearsay was used or there was any coerced testimony. It's the structural failing, that there's the potential that it could be used. But this gets to the heart of sort of our panel here that sets up the rest of the day, which is, why do we have these military commissions? And so if you accept the construct as it was laid out by Colonel Davis, that we began by saying this was an intelligence gathering operation, then one of the things you recognize is that when these individuals were picked up on the battlefield, there wasn't a thought to preparing evidence and gathering it in a way that would allow you to try individuals in court. And so what it comes down to, the debates really come down to for us, are the hearsay issue and the coerced testimony issues that Larry raised. The hearsay issue comes up because it's the intelligence context. The prosecutors, for the DOD prosecutors and former prosecutors, can't really get into the details of what they look at every day, but I'm under no obligation to not say anything. So, I mean, they look at a box of intelligence. Let's just sort of make it as simple as possible. And that information might be provided by a foreign intelligence service who says, this person is really bad, here's how we know it, based on inhuman intelligence, and you can't use that. You can't disclose it in a federal court. And so how then could you admit that evidence in some other tribunal? Well, in a military commission, you would have some other agent come forward, someone from the intelligence community who says, I know this person's bad because I read this out-of-court statement that I'm sitting here offering for the truth of the matter asserted, which is that this person is bad, but I can't tell you where it came from. And that's where the hearsay issue comes in. And so the military commissions basically stands as one big exception to the hearsay requirement that SEPA and these other procedures oftentimes wouldn't accommodate for you. And then the other issue with coerced testimony is if we decide to apply an Article 3 framework for coercion and you use the Miranda framework, Miranda plainly says in the opinion, any custodial interrogation is inherently coercive, and therefore you need the prophylactic measure of Miranda. And so all of the statements, any of them, even if it was just over a cup of Starbucks coffee with an FBI clean team or whatever, is out because it was custodial, it was inherently coercive unless it was warned. And then there's the question of whether or not you can clean up a subsequent voluntary statement after earlier coercion. And so the reason for the military commissions is it's a legacy problem to fix the mistakes that were made earlier because we rushed into the process. I mean, it really comes back, it's path dependency. The earlier decisions that you make have a big impact on your future decisions. They constrain you. And that's the problem we're left with from November 13, 2001, when the Interagency Working Group got cut off and everything that flows from that.
But just to be clear, I mean, just because we have a lot of non-lawyers and particularly people in the overflow room, and I just want to make sure that everybody is clearly understanding that the military rules of evidence are largely derived and reflective of the same procedural processes, particularly with regard to evidence, evidentiary matters, as would be flown in an Article III court. So you've got those Article I military courts essentially applying identical rules of evidence with very slight differences on the margins, but none that are significant for these purposes. So that in turn means all your normal hearsay rules, and it also means, I mean, this is one of the great mythologies, I think, of Guantanamo, in fact, is this idea that, well, everybody is going to be convicted on you know, torturous testimony, etc. It's a flat rule, flat prohibition that says no evidence produced by coercion will be admissible. So at the end of the day, and this is, I think, one of the most important things I want to add to this entire panel. So let me say this now. Where you stand, or where you sit, depends on where you stand. In fact, if you approach this entire process, as many people did, from a perspective of very little understanding of what military judges do, how professional they are, the character of military judges, then you have the tendency to say, well, they're just pawns in the hands of an overweening executive who will simply implement executive will. The track record categorically does not bear that out. Military judges, professional judges, who time after time after time have ruled against the government on a range of issues, from hearsay evidentiary issues to coercion to you name it. In fact, the very first order was to say, hey, this entire jurisdictional framework is flawed. Because here's the statutory requirement. What was done doesn't fit the statutory requirement. Case dismissed. And people were shocked. For the military lawyers, there's no surprise at all. A judge is applying the law and applying it properly. Now, turn that around from the outside perspective. In our field of international criminal law, and I've heard this for nearly a decade in the context of international criminal court debates, people say, trust the judges. And when people begin to point out the gaps and inconsistencies and problems in the international criminal court framework, the answer is always trust the judges. There's a complex legal process there. Trust the judges. They will apply the law properly. I would sit and say that's exactly what's happened at Guantanamo, right? You have procedural mechanisms, and they've applied the law. Not always perfectly, but that's why there's appeals processes.
I am merely the moderator here, but I do want to point out something that happened in Greg's answer, which is that we had been talking about the good faith and good behavior of JAG officers, the military judges, but now that's gotten broadened, right? Because once you start talking about intelligence evidence, we're also saying that you have to depend on the good faith of the intelligence agencies, and not just our intelligence agencies, but of the Northern Alliance when they hand over somebody and say, oh yes, we captured him on the battlefield. And they're not all captured on the battlefield. And we're also talking about various governments that hand somebody over or hand over evidence about somebody that we grabbed. And I know one can define the battlefield to be anywhere and everywhere, but I'm not sure any of you would do that. So suddenly once we get to the harder cases, the ones that haven't been tried yet, there's no, the issue of will good faith make the system work becomes a whole lot shakier, doesn't it? And I want to talk specifically, or I want you to talk specifically about coercively obtained evidence, and to what extent has that tainted the system? This is probably a two-part question, because as you suggested, there's also the can you clean it up after the fact? Once you have waterboarded however many scores of times, can you ever have a non-coercive interrogation, even if you Mirandize?
Right. Ignore the dripping board behind me or however it is. I just have some questions to ask you.
And I'd like to start with Mo on this one.
Yeah, 2 points I'd like to make. One is, I guess one thing I learned in this process is the stark difference in what an intelligence agent will accept as fact and what an FBI agent will accept as fact. For intelligence purposes, you don't have to get to the beyond a reasonable doubt standard. And so I have some concern that some of the statements where it says, the detainee admitted X, did he really, affirmatively state that yes, X happened? Where I know having observed some of the interrogation sessions, the FBI was scrupulous in making sure that the guy really did admit to what he was admitting to. So I think there is a vastly potential for a different, an admission to an intelligence agent and an admission to an FBI agent, to me, do not carry the same credibility and reliability.
I think on this topic, if I'm going to add anything constructive, it has to be in broad strokes. No prosecutor tries to build a case against any accused in any system with evidence that they think is unreliable or going to get overturned on appeal or be suppressed in a suppression hearing. So one thing that our office did under Colonel Davis, and it has done under the following two chief prosecutors, was work on developing our cases with the very best evidence that we have. Again, I have to speak in broad strokes. But there is no one in the office of the chief prosecutor who is trying to slip by the tainted information. We appreciate the issues. The issues are there. The issues are discoverable. We must disclose information to the defense according to the rules for military commissions. So, all of this, these issues we know are problematic in some cases. Far fewer cases than most people would recognize. Many assume that Guantanamo is some kind of waterboarding factory, that anybody who went through Guantanamo was treated extremely harshly at all times, and that is simply not the case. So we not only deal with getting our best evidence that we have, but we also have to deal with the motions that have been raised as far as tainted evidence. So how do you recover from statements that may be tainted the clean teams?
Well, and I want to go back. I'm sorry.
So I just wanted to add to this. I mean, so one of the issues, of course, is if the system that's in place in Guantanamo is as good as some of the folks on the panel have suggested, why not simply move the cases to the U.S. and work within the normal criminal justice process? And the answer is that we're concerned, right? Concerned about whether there will be cases down the road where they won't be able to meet the standards that we have adopted over the last several hundred years in the U.S. So, and there, of course, this business about cleaning up evidence. Well, one standard response is to say, there's a reason why most of that evidence is excluded, straight up, not cleaned up, and that's to deter down the road. And this is an extremely important point in U.S. criminal law, not just from a defense standpoint, but certainly from a defense standpoint. And I continue to worry about that. So the question, could we clean up the evidence? Well, yeah, there are ways that the evidence could be looks slightly less dirty or slightly cleaner, depending on your point of view. But there are also good reasons to think that perhaps it shouldn't be, that in fact it should be excluded, and that's the way that it's typically thought of in the U.S. criminal justice system. So there are, I don't want to impugn by any means, the morality or ethics of the folks who are conducting these tribunals. I mean, it's not a question of the goodwill of those folks. For me, it's simply a question of process. And that's what worries me, and that's what I think we need to talk about.
But I want to go back to the premise of the question, Bob, which was you posited that, of course, you've built in a simple deference, an assumption of goodwill on the part, as you posited, not just of American actors from any agency, but also of international actors. I think that's a false premise because there's no assumption, and nor do the rules require it. And in practice, it's absolutely been exactly the opposite. It's not just a goodwill prosecutor walks in, and Keith walks in and says, "I'm a great prosecutor, Judge. Here's all the evidence." And of course, it all comes in nice and neat on Keith's assumption of goodwill. Trust me, Judge. And that's not how it works, right? The legal standard articulated, probative value outweighs prejudicial effect, and that the judge makes a finding that the circumstances for the procurement of that evidence have sufficient indicia of reliability is exactly the same standard followed in every international tribunal, in every internationalized tribunal, and frankly, in almost every other legal system in the world. That's the way it's done. So it's not just an assumption of good faith, and where we do have other one of the mythologies of the Guantanamo process is that somehow that's exactly what we're doing. We're just sort of cleaning up evidence. And in fact, the procedure for handling that kind of classified evidence or that kind of intelligence-derived evidence is very much drawn from CIPA. So there's an unclassified extract that's prepared, accompanied by necessary corroboration, and fact finders are assessing the reliability of that statement in light of corroborating factors. That's the way it's, and subject to cross-examination, all the normal processes. So I would just sort of disagree with the underlying premise that there is just this assumption of good faith and therefore it all comes in automatically. It's still tested on the crucible of a judge with a judicial mind applying rules. Does this meet the rule or not? And for the prosecutors that I speak with down there, there's a lot of frustration for a lot of evidence that they think is probative that judges have kept out, in fact.
So I think this is where we run into system failure, though. So we're sort of taking little slices here. And so if we look at this holistically, I agree with everything Mike Newton just said. And so let's fit that into the framework that we now have. We have detention authority, and so we run into the issue that we have a heightened standard of proof in the trial process, whereas in the detention process, it's been a preponderance of the evidence in the habeas cases before that. I mean, and that's, Hamdi tells us that you can have a preponderance, you can have a burden in favor of the government's evidence. You can use hearsay for the detention. It's playing out a little differently in the habeas cases, depending on which judge you follow. But the bottom line is that you can detain these people indefinitely. Even the Obama administration has subscribed to that point. So now you have to ask yourself the question, well, why would we bother with military commissions trials if we have to deal with cleaning up evidence, or we might have to disclose some intelligence information? It's certainly not for the incapacitation effect. Is there some expressive value to military commissions? Did we all walk away saying, yeah, that Hamdan got what he deserved? And so at the end of the day, then, the policymakers are faced with the decision, why would we go forward with a trial? Other than if we can ground it in some right that an individual either must be tried or released. And so now we're on the carousel wheel.
I want to follow up with
Sure,
a question, because there's a flat assertion in what you said that we can detain these people indefinitely, and I think I want to start with Larry on whether indeed we can do that, and under what's you don't want to be put on the spot on that one?
So I said I wasn't going to take the floor and give you a long lecture, but I do want to just say that I've just finished a book on the sort of history of habeas corpus and on some of these issues, and it does seem to me that we need to recognize that there is at least an 800-year history of thinking that indefinite detention is not just illegal but immoral and should never occur. And this is, in fact, one of the cornerstones of Magna Carta. It's what arguably is the base of the American legal system. And so to say that we can detain people indefinitely, or even to think that, is to run, in my view, completely contrary to this 800 years of history. And the greatest legal minds, Bracton in the 13th century, Blackstone in the 18th century, these folks all felt that detaining someone without giving them any opportunity to bring questions of their detention was the worst thing that could be done. And indeed, in Boumediene, Justice Kennedy similarly says that habeas is the basis, the most important of all of the rights that we have in the US constitutional system. So, and that's, habeas is what would have to be denied if you were going to hold folks indefinitely. So, I mean, I'm expressing, I'm sure, some exasperation here by the question, just because I think that it should not be a question that's ever asked.
Larry, can I ask for clarification on a point you made, Larry? It's, and you know way more about the habeas stuff than I do, but the habeas provides you the right to come before your captor, right? But it doesn't necessarily guarantee you the remedy. It's possible that it would be adjudicated and then you'll be held to the cessation of hostilities in that theater of conflict, or
yes, of course, that's right. And so I would have to qualify what I just said, to be sure, and that is that if we're talking about indefinite detention where you are never where there's no requirement that you could be brought out of a prison and confront either your jailer or have some kind of administrative or trial proceeding to determine whether you have been properly detained. Yes, that's right. But what habeas has done over the years is to stand for, as a general proposition, this idea that indefinite detention, which means where you cannot challenge your detention, is simply ruled out of hand.
Can I, first with the caveat, I'm not one of the great legal minds that Larry is referring to, but in my simple way of thinking, I would agree with every. I would agree with his statement about indefinite detention. If you're talking about somebody being indefinitely detained for being an alleged robber of the corner liquor store, I disagree wholeheartedly in the context of war. I mean, I don't know of a single war when it started that we knew what the end date was going to be. So inherently, the period of detention is indefinite in time of war. I mean, as General Altenberg alluded to, back in the old days, before the Treaty of Westphalia, if you were captured in an armed conflict, you were either executed or enslaved. So this notion of indefinite detention seems a lot more humane than either of those two options. But I'd wholeheartedly disagree that in time of war that the 400,000 World War II detainees that we had here had a right to their day in court.
I would just like to express my agreement with both Colonel Davis and Larry
in the middle. Seated right in the middle, yeah.
on the one hand, if we're talking about indefinite detention, if we're using that true language, then there must be meaningful review of that detention. There's no question about it. On the other hand, if we're talking about an armed conflict, right, the rules clearly state in Geneva III that you can detain an individual during armed conflict until the end of hostilities. And as General Altenberg pointed out this morning, that's a question that we really need to come to terms with. What if we are in an armed conflict where there's no end in sight? It's not going to end in a peace treaty, right? And we're not going to simply release our enemy across enemy lines, whatever those lines may be. We have to take a good hard look at what the procedures are when there's an indefinite conflict.
Now, there's a really important systematic point here, which is the interface between military processes and Article III federal court processes. Larry alluded earlier to the human rights discussion, which we can certainly have, and many of us have had in other academic forums, and Laura's written extensively on, et cetera. But the human rights standard is prolonged and arbitrary detention, no prolonged and arbitrary detention. Ergo, what logically flows from that, of course, is the right to challenge that detention. A commonly accepted, as we say in the law, a standard of law accepted by civilized nations all around the world, right? That's not in dispute. What is interesting, two things. One, that in the processes, and not many people really recognize this, historically, in an armed conflict, there's been the preliminary decision that, yes, we have valid authority under the laws and customs of war to detain this person. That right in itself has never then been subject to periodic review. In this process, it is subject to periodic review, which as far as I know is a first. I don't know of any other example where people detained under the authority of the laws and customs of war get multiple bites at the apple to prove or disprove. But that points up what I think is the deeper problem, and again, to go back to the themes of our conference, something that I believe has to be fixed by the Obama administration, has to be looked at very carefully, which is the sloppiness between what military investigators are doing and incorporating, of course, in some cases, statements and observations from other parties in other nations, etc. When you look at that in the context of the actual habeas litigation, Parhot v. Gates is my example. You know, the D.C. Circuit looks at Parhot and says, you know, the military walks in very confidently, DOJ walks in very confidently and says, here's our evidence. Boom. Send them back. D.C. Circuit looks at it very carefully and meticulously, and importantly, on the inferences and the presumptions to be drawn from that evidence. And there's a disconnect where the practitioners in the field have a very minimal base of evidence and then make inferences and conclusions drawn from this evidence. That may be fine for an administrative process. What we're seeing repeatedly in an Article 3 review is that it's not fine. And there's a disconnect. And it's really important to me because what we're not doing now is following that up with military people in the field to say to them, look, here are the inferences, here are the problems that are being encountered based on the inferences and the practices in federal court. So if you want this guy that you pick up in whatever Pakistan province to actually stay in custody, here's the standards of review and here's the inferences that are causing people, in the case of Parhot, to actually be released. There's lots of information, but the D.C. Circuit pretty flatly says there's a real standard of review here, and we're Article 3 judges, and this doesn't get it.
Can I go back to Boumediene real quickly? You brought that up. And I think it's another example of you know, what I would term the arrogance and the ignorance of some of the folks in the last administration. If you recall, in the spring of 2006, and when Boumediene first went to the Supreme Court, the court refused to hear the case. Then several months later, for I think the only time in my lifetime, they reconsidered. And what happened in the interim was, you know, Lieutenant Colonel Steve Abraham came forward and said, I participated on these panels, and in many cases they were a sham, and if we didn't get the result that the leadership wanted, they sent it to another panel until they got the right result. Which I think, you know, I certainly don't know what the Supreme Court's thinking was, but I think that was an important point, that they were willing to give deference to the executive branch until, you know, that came out and called into question whether that deference was still due. At about the same time that was happening, Keith and I were at Guantanamo. We had the Cotter case and the Hamdi case where the judges bounced us out of court saying there was no jurisdiction because of the defects you mentioned in the Military Commissions Act, the jurisdictional language, and the finding of the Combatant Status Review Tribunal. There were a number of us, including some fairly senior folks in the Pentagon, who saw this as an opportunity to rewrite the rules for the Combatant Status Review Tribunals and maybe kill two birds with one stone. Show the Supreme Court that there is a robust process where an individual can challenge the basis for his indefinite detention, and to clear up the jurisdictional problem, the missing word unlawful from the CSERT finding. So we could have rewritten the rule and done both, I believe. But there were folks in the administration that said, wait a minute, we wrote the rules for the CSERT, we were right, we knew what we were doing, and we don't need to redo it. So you go in there and argue that we made the right decision. Of course, now we were left having to appeal to a court that didn't exist because the administration hadn't gotten around to creating the Court of Military Commission Review. It's kind of hard to file an appeal when there's no court with no judges and no address to send the appeal to, but that was what we were told to do. But to me, it was another example where arrogance and ignorance overrode common sense, and we could have perhaps avoided the Boumediene decision if we'd have just done the right thing at the right time.
So we're supposed to be looking back on this panel, and I think one thing we need to look back on is that the Bush administration consistently opposed giving habeas rights to the folks at Guantanamo. And so the idea that they could in fact challenge their seemingly indefinite detention was for quite a long time denied by the Bush administration, and they fought very vigorously to prevent that. So that where we are now, since Boumediene, is of course a different story than where we were for many years before that. And I just want to point out that there were several other reasons for why you want to have habeas protections other than the fact that someone could get out of jail or out of detention. And this has been the sort of folk history of habeas for many years, that it isn't just a matter of making sure that the innocent are released, but it's also a matter of the folks who may very well be guilty, but make sure that they're treated properly. And that's been, for centuries, one of the main things that habeas has protected. And that was what worried most of us in looking at what was happening at Guantanamo, that because you didn't have review of any sort for a very long time, there was a considerable worry. And now it looks like some of it was justified and some wasn't, but there was some considerable worry about how these folks were being treated, about whether they were in effect being disappeared in a way that was reminiscent of what happened in Argentina many years ago. And so these are the kinds of things that habeas was needed for, and until quite recently was lacking. And that's one of the reasons, looking back now, why Guantanamo was such a black eye on the Bush administration.
I'll ask one last question and then open it up to the rest of you. What's the legacy of the military commissions in terms of military justice, in terms of how the military justice system is regarded, in terms of how the United States is regarded in the rest of the world? What's come out of all of this? Greg, you're nodding.
Yeah. And I'm the junior guy, so I'll start for just in seniority purposes. I think that fortunately, you framed it as a military justice question. I think fortunately, the focus of our discussion has not been those darn military officers who did us wrong, right? And so, and some of the things that Colonel Davis is too nice to not bring up were things that he and I have spoken about, where political appointees sort of thought that the military was going to roll over, and General Altenberg brought this up. There was one political appointee, and I think it was in DOD, who said something to the effect of, if those JAGs were any good as attorneys, they would have real jobs in the private sector. Another statement made to Colonel Davis was, we can't have acquittals. What do you mean some people might be acquitted if we go to trial? Well, okay, well, let's just sew the costumes and bring the drums out and skip the whole trial process if that's your approach to this. And so I think what you found was that, we see it, a lot of the defense side was honored for their efforts, but also I think if you look at on the prosecution side, we saw prosecutors who stood up for what they believed in, and some of them stepped down from very promising careers as prosecutors. Colonel Davis's star was on the rise, I suppose, and made a stand on principle. And I'll actually say one other thing on this. I sat in this room in 2004 or 5, right after Colonel Davis became the chief prosecutor. He came up here and he said, he said to an audience just like this, in this very room, he said, if I'm ever placed in a position where I feel like someone's telling me to do something that I think is wrong or offer evidence that I think is wrong, I will resign my position and I'll walk out because my integrity's not worth it. And you sort of sit there in the audience and you think, yeah, you're full of it. Nobody ever does that. And then what did we get? A year and a half later, the man stepped down. So I think the legacy for military justice is that we can trust the type of rule of law training that military officers are given that honors international law, and we can trust that ethical culture better than we could have trusted some political appointees at some points in time. So
yeah, I want to take a slightly different dichotomous perspective, which is not quite to answer your question, but to go back in time just a little bit. I mean, your question is, what's the legacy? And I agree with Greg, but from a slightly different perspective. In the fall of 2001, and I was in the Interagency Working Group. I mean, I was the one writing the documents. So I know this emphatically. One of the concerns, particularly of the military attorneys in the room, was that whatever was done properly, it was done lawfully, it was done carefully, and it was done with the greatest possible explanation, as I think good lawyers do, of the benefits and costs and the pros and the cons and the considerations and the second and third tier effects. Let's fully and properly inform the executive with a good, holistic decision-making document, and then the executive makes a decision. That's the process that was short-circuited. One of the most vibrant, real, almost omnipresent concerns, particularly among the military attorneys, but not exclusively, was the sense that if we don't do this right, that it will automatically lead to this bleed-over assumption that military professionalism isn't what it should be. That it will, in fact, have the perception of corroding the American military justice system, which uniformed lawyers are extremely proud of. It's well implemented. It's, we can give you all, that's a different discussion. And of course, we all know the history, right? That was short-circuited. So there was, in the early phase, this very strong backlash of, hey, they all work for the executive, and it did, in fact, begin to corrode. Now we've seen the pendulum swing back the other way because of the particular courage and the particular professionalism. So I think one of the legacies is, to pick up on Greg's point, that it has reinforced the necessity of the professional ethos for uniformed military attorneys. You know, other attorneys, where there's professional violations, fine, you get disbarred. Right? You run that risk. You want to go collect trash, fine, go get disbarred. For a military attorney to perform in an unethical, lack of integrity, unprofessional standard actually causes in my mind anyway, a far greater disproportionate damage to the integrity, to the professionalism, to the very deep fabric of what it means to be a professional, and for our purposes, an American military professional. I think one of the legacies that we have to build back into our training base to young military attorneys is, don't take that for granted. It only has validity and sustained viability when it's a conscious, almost like the eternal flame. I think that's very important. And then the second minor point, which I won't talk about because I've written about it in the piece for this, is the continuing, although we can debate the wisdom, we can debate the circumstances, but in fact, the jurisprudential legacy is clear that military commissions are a viable constitutional alternative. I mean, that's not been defeated in any Supreme Court case. They have to be done properly, which was the theme that we started out with. And that's one of the legacies now, for the first time since World War II, we actually do have a revalidation and in fact, a clarification of the ways in which they must be done and should be done properly. But that underlying premise that they are valid, that they are constitutional, that they can be efficacious has been revalidated repeatedly.
You know, every generation we need to reaffirm our values, and this was an occasion for doing that. And when a senior member of the Bush administration said that they were creating a situation which was the legal equivalent of outer space, what happened was a lot of things that the folks on this panel have talked about that blunted that. And that was extremely important, and it'll be extremely important, at least for another generation, until something again happens that causes us to question whether we want to reaffirm these values yet again. But that was a significant challenge to the military lawyers, to all lawyers, to the all-American citizens when the Bush administration officials tried to make that case. And that, for me, is the legacy. Most significant legacy is that we will not allow anyone, no matter how powerful in the U.S., to create a situation like that again.
Well, first, I appreciate Greg's kind words. Not everybody shares that sentiment.
It's true.
General Altenberg mentioned about doing the award packages. When mine went forward, the Department of Defense said I served dishonorably because I quit and became a critic of the military commission. So not everybody is of the same opinion that I did the right thing. I think the legacy, I think it's an unfortunate legacy. I think military commissions could have been something that we could all be sitting here today proud of the way our country behaved under extreme stress. I mean, I'm willing to forgive, you know, if you go back to 2001, we had, you know, the September 11th attacks, we had anthrax, in D.C., you had anthrax, you had the Beltway sniper. I mean, D.C. was about one crisis away from just a complete meltdown. So I'm willing to forgive people for making some bad decisions under that stress and strain. What I'm not willing to forgive is after there's time has passed and there's the opportunity for reflection and the mistakes are pointed out, that they insisted on writing those mistakes into the ground. And unfortunately, that's the legacy that we're left with. It could have been a proud day for the country, and it's not. My fear is, as I've stated before, that the military commissions are military in name only, that it's a political controlled process, that when I was there, it was always a tug of war between DOD and DOJ. For the DOJ attorneys, this was, getting to prosecute Khalid Sheikh Mohammed and folks like that is something that is very desirable. So trying to keep them at arm's length and keep this a military process was a challenge. Of course, now the current chief prosecutor, who was a person that started there when I was chief prosecutor, he came on board as the Department of Justice attorney. And now he's a great guy, but it's a full-time DOJ attorney now running the military commissions. The convening authority, is a political appointee who's never worn a military uniform a day in her life. Since 2001, there have been roughly 75,000 court-martials convened by convening authorities, and to my knowledge, not a single one of those was convened by a political appointee. So if these are military commissions, why is the military not in charge of it? I think when I stood here, actually it was in 2006, March of 2006, when I stood here and I defended Guantanamo and defended military commissions, I honestly, people asked me, You know, was I just saying what I felt I had to say because of my job? I honestly believed we were going to have full, fair, and open trials. And I think where the train left the track started in late 2006 when General Altenberg left and went back into private practice. I mean, I had the utmost faith and confidence that you know, he was there to do the right thing and ran interference and kept the political appointees in their proper place. So when he left, I think that was the beginning of the end. His legal advisor was Brigadier General Tom Hemingway, who also was a career military officer and also put a lot of weight in protecting the integrity of military law and military lawyers. He left and was replaced by a reservist who was a corporate attorney. And I think that was when I saw the headlights coming, that this had become a political process and not a military process. As I mentioned, you know, when President Roosevelt had a chance to do a military commission over again in 1944, he turned it over to a military commander to be the convening authority. So my argument was, if these are military commissions, give the mission to the military and let them do it. It's unfortunate that didn't happen. I think it's too late for that to happen now. But this could have been a proud chapter in our nation's history, and it's not.
I guess as the junior or second junior member of the panel, the person with boots on the ground, I will tell you a war story of actual boots on the ground in Guantanamo. It was January 19th of this year, the day before the inauguration, and we had just started the suppression hearing in the case U.S. v. Omar Khadr. As you know, in all of these cases, the defense is going to allege that any one of the detainees or the accused was treated harshly during their time of detention, and so any statements they made during that time cannot be admissible. We put on 2 witnesses. One was an FBI agent. The next was a DOD intel interrogator. The defense did not have the opportunity at that time to put on their witnesses because at 11:30 on Tuesday, January 20th, the military judge said we are going to recess. For any of you who would like to watch the inaugural events, you may do so, and we will reconvene tomorrow unless instructed otherwise. We all knew that we would not be reconvening on the 21st. In fact, that night we received the order to request a continuance so the executive task force could review the procedures. The following day, that afternoon was filled with mixed emotions. We watched on the TV the inaugural ceremonies, and from anyone's perspective, I don't care about your political persuasion, it was awesome. It was awe-inspiring, and it was a tremendous event. As far as we prosecutors upstairs at the courthouse were feeling, we were very disappointed that we were 1 week away from the scheduled start date of our trial, which we'd been working on for me at least at that point, 2 years, and for others more. As far as the legacy of the process, the feelings at that time were simply that military commissions, under the Military Commissions Act, okay, so I think we're all in agreement that they were off to a false start in the early years. But under the Military Commissions Act, in my opinion, I'm not sure what the legacy will be, would have provided full and fair trials. There are some exceptions. The amendments that they are making to the MCA, one in particular is the elimination of the use of coercive evidence. The provision in the MCA that allows different treatment of evidence prior to the passage of the Detainee Treatment Act and evidence after Detainee Treatment Act, let's just face it, it's embarrassing. I mean, I don't think I'm going to get into any trouble for saying that. That's one of the legacies, unfortunately, that we live with under the 2006 Military Commissions Act. Otherwise, our practice had been in over the 100 pretrial motions that we litigated in the Khadr case, that there was a robust defense. The legal issues were out there. During that suppression hearing the day before and the day of the inauguration, any of these hot-button issues, coercion, the reliability of statements, these were going to be litigated, and were litigated, started, in open court, okay, and decided by a real judge.
We're going to open up for questions now, and I'm going to ask you, and I apologize for making you walk down here, but we are webcasting. We want everybody to hear your question. So please, if you have a question, come on down. Oh, we have another microphone? Oh, never mind.
Scott's very shy, so.
Scott Silliman from Duke. Many of the criticisms that have been made by this panel, the admissibility of coercive testimony taken before the DTA, hearsay, these have already been amended by the new General Counsel of DOD in May of this year, and as all of you know, in the Senate bill, they have been codified, including the proposal to do away with the Court of Military Commission review and replace it with the Court of Appeals for the Armed Forces. So to some extent, the new military commission procedures, if they pass and come out of Congress that way, will come very, very, very close to the rules of procedure and modes of proof for courts-martial. The one thing that I'm interested in, and Mo, perhaps you're the one to answer it, is much of the stain of military commissions was caused by the perception of over-politicalization, including Tom Hartman and Jim Haynes and the rest. If you were advising Congress right now, besides fixing the rules of procedure, you've already got in the Military Commissions Act a provision which you got in, Mo, to ensure the independence of a prosecutor. Right. Where would you go further to depoliticalize the process?
I would turn it over to, I would assign it to one of the services and make it a mission under the responsibility of the uniformed services. Get the DOD General Counsel and the political appointees. I mean, they certainly have a supervisory role, but that should be the extent of it. It should be a military mission assigned to a military commander to execute. And I think the process could work. Again, as you mentioned, I'm afraid though, I'm afraid military commissions have become like Guantanamo itself. There's this negative perception about Guantanamo. And I can tell you, I used to be a bail bondsman, so I've seen a lot of jails. And I think there are a lot of Americans that are locked up that if they had the option of going to Guantanamo and they saw the place, they would take that option because it is a very safe, clean, humane facility. But just the name Guantanamo is so tainted that there's, you can't erase it. I'm afraid military commissions have become the same way, that it would take, one heck of a PR campaign to try to erase the stain that has existed up to this point. I guess another concern I have is with the, right now it appears that there are, I think, 30 cases that are being reviewed to go to federal court, is how are we going to articulate having two standards of justice? If it's a good case with good evidence, you go to the good court, and if it's a half-ass case with half-ass evidence, you go to the half-ass court. And that's the perception that it's going to create. In my view, it's got to be all or none. Pick a forum, and that's where the cases will be prosecuted. But to say like Galani, he was one of the 14 high-value detainees that shows up, and now he's going to get a full measure of justice, but Khalid Sheikh Mohammed's going to get a half measure or something. That's under the pre-indictment charges, Mo. That's not on anything related to 9/11. That's the right.
1998 embassy bond.
Right. I know, but the perception, because right now there are 30 cases that are being reviewed to go to federal court. And if you watch the testimony from Mr. Chris and Jay Johnson, one of the standards, and somebody correct me on the language, one of the criteria in evaluating cases to go to federal court is, you got the language? I do. Oh, what does it say?
Can we win in one or the other?
And evidentiary issues?
Yeah, one of the criteria is the evidentiary issues, which is really saying, if the evidence is good evidence, then federal court's the right way to go, and if it's not that good of evidence, then military commissions might be the right way to go.
Scott, on your, just a follow-up on it quick, so I make two recommendations in an essay in Northwestern about these structural issues that you're talking about. The first relates to what Colonel Davis was saying, the making the convening authority a political appointee. And then the second is one that's it's a point that's also echoed by Gene Fidel, in that the rulemaking process for the Manual for Military Commissions should be similar to how we follow for the Manual for Courts-Martial, right? I mean, open for public comment, as opposed to this sort of insular development process where all the rules of the tribunal are generated in, I don't know where they were generated, in the General Counsel's office or something, but not notice and comment rulemaking or anything even approximating it.
Well, and just to pick up on that, insular was the word that I threw out in like the first 3 minutes of the panel. There's a good insularity and a bad insularity, right? The bad insularity is the insularity of the rulemaking process, which I think has to be opened up. The good insularity, though, is in the functioning of the processes, et cetera. And one of the things I would specifically recommend that we do is to extrapolate the specific rule from the Uniform Code of Military Justice, which makes it a felony level offense to interfere in the processes of a commission. right? So extrapolate that and make a very clear, look, it is a crime under United States federal law to interfere in the judgment of any actor, judge, witness, and of course the witness tampering issues which come up, but more particularly in the professional discretion of those people charged with the production of evidence and the defense of that. Political interference becomes a punishable crime. I think that's not too far to go. And that may be one of the things that's necessary as you talk about really driving a stake in the ground to change the perceptions.
I'm going to try to direct traffic. I see several questions. Judge, we'll start with you, and then Jordan, and then I don't know your name.
Thank you. Raed Juhain, Iraqi judge, and I'm student in case. Thank you very much for this distinguished discussion about the Guantanamo. But what I like to take Guantanamo example, where they located a couple hundred individuals there, to practical life overseas in Afghanistan and Iraq, where the homeland for Al-Qaeda and the practical life for the Al-Qaeda operation in Iraq. According to the security agreement between Iraq and United States, there is two kinds of detainees, security and the criminal. Criminal is no problem, pays justice, but security, it's the biggest problem. Security detainees, we have Buka also, like Guantanamo. There is a lot of intelligence information regarding these security detainees. And when they start to collect and arrest these guys, the violation decrease immediately 2008. When they start operate with the security agreement, and they start release the security detainees, many information, many reports, even many evidence show they start their operation again. Last two examples, last 40 days in Iraq. 4 security detainees just released from Buka within 6 months, last 6 months. 2 of them used tract and explode the tract in Kirkuk in the middle of market and killed 300 individuals and injured 900 individuals and destroyed 20 stores. Last 10 days, last 15 days exactly, a couple of weeks from now, 2 big tracts. One attacked the building, the main building for the Ministry of the Finance, and the second one attacked the Ministry of the Foreign Affairs. Killed 100 individuals, injured 900 individuals. My question is how to balance the rule of law with the safety and security and the stability for people in the society. It's clear, as the colonel said, it is not judges' work to, if there is no evidence, I will release them. You know, this is my job. I can't keep innocent person in jail. But the prosecutor job, if the government kept them in the custody, can he prosecute the government because they kept innocent people, no evidence against them? Or keep silent and leave innocent people in jail? And he knows in his mind, if they release them, they will kill him maybe, or kill his son, or an innocent person, because intelligence information mentioned that, but it's classified. No one can use it. My question, how to balance that?
Well, I think the combatant status review tribunals and the annual administrative review boards, I think, could be a process for the folks that there's no intention of ever prosecuting them for their past conduct, but we don't want to release them. We believe they're a continuing threat to our safety and security. I believe they're, in my view, they're entitled to a robust, meaningful opportunity to confront the evidence against them. And if that evidence convinces, whether it's a judge or a panel, whatever the right forum is, that the person should be detained for the safety and security of us and our allies, then they ought to be detained and reviewed annually. Unfortunately, the way the process is now, if I'm the accused, they call me into this proceeding, and then they, inform me what the rights are. And then they say, well, the evidence against you is classified, you can't see it, and I have to leave. And then they call me back in and say, boy, if you could have seen the evidence against you, you'd understand why we're keeping you, but of course you can't see it.
I swear we have a good case.
Yeah, and I think that's wrong. I mean, if we're going to detain somebody indefinitely, they ought to have an opportunity to know why they're there and to confront the evidence. But I think if we give them that opportunity and the evidence suggests that they're a continuing threat, they ought to stay in detention.
Yeah, there's a really good book written about the Saddam trial that helps people understand how to balance some of that. At least I think it's a decent book. But I think that the real shorthand answer to your question, Judge Rod, is the absence of political interference, right? So that judges really are very clear in their assessment, and I, unlike some others, reject the assertion, not necessarily in this panel, I'm not speaking, but in the community at large, reject the assertion that the only way you can have a process based on the rule of law is one that's where the judge's hands are tied by a strict. That's not the way we do it in other processes, right? We defer to the judge. We say that you can consider this whole range of evidence and do what you believe best based on the law and the probative value of that evidence. But that only operates on the presumption that it's not subject to external controls or political interference, or in the Iraqi context, the fear of debatification, or the fear of loss of pension, or any number of other things. And so to the simple answer, easy to answer, much harder to implement, is a revalidation of what we mean by the rule of law, is that the judge is there to do what is right and apply the law.
And of course, we should remember that these issues are not unique to this particular time. The conflict between security and rule of law has been an issue for hundreds of years within the U.S. and for much longer than that in other parts of the world. And we sometimes think that the so-called war on terror changed everything, but it hasn't. These issues are very old, and in almost all cases, the rule of law has been seen as the dominant value, and security has to take a second place. And I think that's the way it should be here as well.
Unfortunately, I have a timekeeper whispering in my ear, and two people that I've promised. Okay, I have one person now. Can we get a microphone? And this will have to be the last question.
Okay, this is really short, except I don't know how you're going to answer it.
Nor do we.
If I can imagine someday in the distant future, my grandchildren concluding that we've vanquished Al-Qaeda, the war on terror is over, what do we do with those folks that our relocating them to Cuba has resulted in their being expatriated from their country? I cannot imagine any sovereignty accepting some of the folks that we have a NAMBY attitude towards ourselves. I think it's akin to us saying, look, we got too much nuclear waste. Can we bring it to your country and dump it? Yeah. So what do we do with those folks who have no place to go?
Well, this is a real problem. Part of the executive task force review is examining just that. They're looking at every single detainee's file. They're looking at which of those detainees could simply be repatriated. They're not going to be tried before a military commission or federal court, and they're not eligible for indefinite detention or whatever it's going to look like. And they have real problems. Now, I don't want to speak outside of my lane because that is an issue primarily for the State Department. But this is giving us considerable concern. We know we cannot return someone where there is reason to believe that they're going to be mistreated in some way, right? So this
your point's very valid, though. I think we're hypocritical, like with the Uyghurs. And I don't know how many. I think there are 30 countries we approached saying, "Look, these guys are not a threat. They're not dangerous. We picked them up, by mistake. Would you help us out and take them?" Then, when a judge ordered them released into the U.S., we go into court and file a document saying, "Hey, these guys are too dangerous to release." So it's if we got to be we got to walk the talk. If we're going to try to tell other people help us out, we got to try to help ourselves a little too, and it may mean we have to take some ourselves.
And there is actually a really good answer to that, which is in terms of, again, I'm trying to capture the spirit of this day, which is to look forward. And the spirit of your question is, what do we do in the future? Keith's right. This is a real problem that's been faced for the last 4 or 5 years. That's why, you know, the numbers at Guantanamo now are way down, because we have shipped many people back. I tend to fall into the camp that says, and of course right now the Europeans are bitterly resisting that. They don't want them. You know, people don't want them. I think we actually long-term need to have, like the Brits have the control order system, some specific mechanism for bridging the gap between total unconstrained freedom, which makes a lot of people uncomfortable for a lot of reasons, and, you know, the current standard of incarceration. There are some statutory schemes around the world that give you some middle ground. And there's some that are clearly improper and that have been tinkered by the courts, and some that have been upheld and that are workable. And we have nothing like that really in the United States practice. Maybe we need something like that, which gives us the vehicle to say to the Uyghurs, yeah, come on in, and to disaffected communities who don't like it, yes, but let us explain to you the processes and the statutory scheme by which we can balance, as was pointed out, the needs of community security with the rule of law.
And I promise that this question was not a plant, but with regard to looking to the future, this is the subject of the next panel, which we will take a short break. I want you to join me in thanking our panelists.